of arbitration, which the Arbitration Act, referring to the legislative scheme, Section 11, Different Interpretation Law Commission, it has been held omitted 6A would continue to apply and guide the courts on its scope of jurisdiction at stage 1 pre-arbitration stage. So, my lord, this is the...
Therefore, what you're trying to put to you is from Patel Engineering, paragraph 12, we pointed out majority takes the view. The court in 11.7 holds that there is an arbitration agreement exists.
Then it's over.
Then it should be over in terms of the majority. Not open to the arbitrator to rake it up in, the parties
At all.
rake it up, number one. Now, SPB, the majority has been overruled.
Registered.
And the text is changed because of the introduction of 6.
Correct.
Now, interpreting this Dolia
and
the earlier judgment appears to be one way of doing it is
yes, ma'am.
That the High Court or perhaps the court under Section 8, when it refers in a case which is a little nebulous,
right,
where, prima facie there is an agreement, exists an agreement. But the court does not want to really finally hold there is an agreement.
It can then...
Device can be to actually expressly make it clear that, we are doing it in this way. We will not take away your right
under 16.
Under Section 16.
Correct.
One that might perhaps hold a key
yes,
to solving this problem as to in which case the parties are yet free despite a finding.
Yes, ma'am.
Or the second thing is the court should not go elaborately into it.
Correct.
You begin with that.
Right. Or if it is obviously but not manifestly, if the court feels that this can be closed quickly, then the court can close it.
Matter is over.
So, my lord, it is really as...
So it really depends on, what the court will really get to say.
Right.
First of all, understanding, the limited nature of its jurisdictions at that stage.
My lord, the practical situation is this. Your lordships are a court. The High Court is a court. Courts want to decide.
That's it.
That's the normal. So that's the normal, my lord. It's very difficult for the court to say.
What the court can do is
to step back.
The court say, step 1, there is an agreement. It is in writing. It discloses that there is an arbitration agreement. Okay. X, Y, Z factors are urged against its validity, even against its existence.
Even existence.
The court finds that these are matters which are better gone into in a section 16.
Correct.
So there the court says there is an agreement. We leave it open to you to take all your preference in section 16.
The Alice in Wonderland case, my lord.
The real solution is this court may make it clear.
Court will make it clear.
Foreclosing your right under section 16. The matter will
in
be
fact,
over quickly.
Your lordship, that clarification has to be given, my lord. In fact, in Praveen Electricals, that was specifically made clear.
Do that at the end of the matter. You don't have to sit in for years together, like 11 years in Jammu and Kashmir, where you spoke about. It can be avoided if you have this.
My lord, it is basically something which is against the nature of the judge. The judge is there to decide issues. But here, my lord, the judge has to step back and leave it to somebody else. It goes against the judicial, my lord,
it's a change in law.
Nature.
The legislature has
wants
the text of the act, and therefore SBP has been overruled. We have to accept that. Unless we
have to accept that
is wrong.
Therefore,
para 12, which appears to suggest that if once a court enters a finding regarding even the existence, there is a bar under section 16. That may not continue to hold good, but the care must be taken both in the exercise of jurisdiction under section 11, 8, and also making it clear appropriately in the order.
Lordships will clarify.
If that is done,
there should be no problem.
Clarify the whole thing.
There should be no, my lord, that actually happens in cases where it doesn't go to court. It happens, my lord. You appoint subject to this, and then you go ahead. And you first preliminary point you raise, it is void, it is contrary to competition law, it is etc. etc.
As they would say that the cause of arbitration will be served even by those who stand and wait, not necessarily that by not adjudicating you are doing injustice.
Yes, not. In fact, this is a case where the court need not
step back.
Should it's difficult. It is difficult because
by tendency,
and my lord, if your lordship sees some injustice, then it is very difficult to tell a court, now you don't look at it, my lord, please send it to the arbitrator. That is something which is as my Lord Justice Bose said, the case of the piece of paper with the arbitration clause. The court wants to step in. So, my Lord, there, of course, there's a Consumer Protection Act.
Praveen was a case where they found that there's no existence. Yet Supreme Court did not disturb because there are a lot of evidence.
There were a lot
also
of
that had to be
evidences.
taken into account.
It was a concocted agreement. It seems like
That Alice in Wonderland analogy came in only because of the situation prevailing there.
That's right.
It was not in existence.
Not in existence.
I have forgotten how to speak English.
That's right.
See, if you do online transaction, the offer and acceptance is complete, then the goods arrive, and in that product description or something, there is inserted an arbitration clause.
Yes,
That is post-contract.
post-contract. Well, no, there, of course, there is another point. That's a consumer
Okay,
dispute.
we don't want to engage in that, but
There, well, not, then that it may not be arbitrable at all because it may be a consumer dispute. There are
somebody may like to go to a suit court also.
somebody may like to go to a suit.
Then that Section 8 question.
Section 8 question will come.
But we must not get derailed too much because here we are on a stamp.
We are on a very limited.
So therefore, otherwise
Otherwise, this discussion will continue. Mulad, let me then, Mulad, just place 34 and 41. SOR. Don't place SOR.
One more thing, see, at the time, the decision in SPB was rendered.
Correct.
The position of Section 6 was different.
6 was different.
It was totally different.
Totally. Mulad, in fact, therefore, 6 was interpreted in that particular way.
And again, then Section 7 was also there. I mean, subsection 7.
7 is still there, Mulad.
But then
7 is still there. Mulad, it's there. 7 is still there.
by the present ones, after 6B, it is 8.
No, that may be in the 2019 it has been delayed. 19 it has been delayed.
7 also.
7 has gone in 19. It is still there.
Up to 9. That is Act 33 of 29.
That has not been notified, that portion.
That is also.
That's
just like.
so, Mulad, it is unclear what the law is. Some portion is deleted, some portion is not notified. There is a very nice chart.
In SPB, Section 7 was also taken into consideration.
Yes.
But Section 6 at that point of time, it was totally.
Totally.
But still in paragraph 15 of SVB, there is a finding that that decision is judicial, in excess of judicial power.
Yes, Mulad. That's where
It's not administrative.
it's
Paragraph 15 very categorically held that it is in exercise of a judicial power.
Mulad, I just want
Paragraph
to,
15.
right. Mulad, may I just now show Mulad? We've shown section 16, Mulad. The Lordship will just see 2 more sections and I'll just show the law commission. At 4 and 45. My lord, just see before the law commission. Please see, I just complete the act, my lord, and then come to the law commission, which will perhaps assuage some of these issues. My lords have seen 16. Just complete it. Please come to 34 for me. Yes. Ayavati also.
Followed by in
Praveen.
Praveen and-
Please, Judge. By Vidya Jolia. That seems to.
That appears to sort of precise the law, apart from overruling. Instead of the limited nature is stated level.
Right. Yes.
See
Yes.
whether it exists. That's it.
Manoj, Vidya Jolia, little bit of fine tuning, little bit may happen.
Little bit.
It may happen.
You're right.
Manoj, just see 34. 34 is a provision, my lord, which is effectively a copy of the model law. And the reason I am showing 34 is, my lord, 34 has two limbs. 34, my lord, 2A and 34 2B. 34 2A is a defense raised by a party. 34 2B is something that the court can find by itself. There is a distinction, my lord, normally people do not notice. Then your lordships will note that 34A has 5 different subheads. Your lordships have 34 2A. Arbitral award may be set aside by the court only if the party making the application established so and so, one party is under incapacity, etc., etc. There are 5 subheads of 34 2A.
2019, 5 and 6 years. Yeah.
34 2A has 5 subheads and 34 2B effectively has 2 subheads. Well, not each of them are different, and there is a reason I am raising this, my lord, because it has some relevance to Vidya Jolia also. My lord, may just see 34 2A 2. 2A2 says the arbitration agreement is not valid. So it is invalid under our law. That is one situation where the agreement itself is invalid. Validity may possibly also include existence. Then, my lord, please contrast it with Roman 4. The arbitral award deals with a dispute not contemplated within the terms of submission or contains matters beyond the scope. My lord, this is little different. 2 is validity of the clause. 4 is a dispute which does not fall within a clause. My lord, this may be relevant for Vidya Jolia.
Yeah.
Then, my lord, a different heading is now 2B1. 2B1 is the subject matter of the dispute is not capable of settled by arbitration. So this is subject matter arbitrability. This is the issue, my lord, which was raised in Jolia. Namely, that even if there is an arbitration clause on the face of it, but in fact it is barred by landlord tenant. And then, my lord, the next heading is public policy. So public policy is treated differently. Dispute not capable of arbitration is a matter only for the court to decide, because the court will ultimately, even if there is an award, even if nobody raises it, court will decide. So, my lord, this is 34. Your lordship will just note this. And, my lord, 45. The relevance of this, my lord, I'll come to later. But 45. 37. Conditional appeal. Leave it. 37 to 37 is the appeal provision, which shows only there's a conditional appeal in 16. And then, my lord, 45 is in part 2. My lord, I am only, this is actually under the New York Convention. We are stricto sensu not concerned with. But it uses the expression unless it prima facie finds that the said agreement is null and void, inoperative, or incapable of being performed. So, my lord, if your lordship steps back and now looks at the Arbitration Act in entirety, Section 8 uses the word validity. Section 11 uses the word existence. Section 16 uses the words existence, validity, jurisdiction. Section 45 uses the word null and void, which means validity, inoperative, incapable of being performed. In different sections of the same act, very different phrases are used.
Have you given this
I've given
description in your note?
I've given the description at page. My lord, we will have to give some meaning to the text also. So where existence is used, please use existence. Where existence or validity is there, please. So, my lord, after all, the legislative, my lord, intent is reflected best from the language. So, my lord, this is so far as the act is concerned. Now, my lord, the most important amendment came in 2015. And Again, my lord, we are going away slightly from stamping, but it has some relevance. Please now see the Law Commission report, which has been now, my lord, referred to in n number of judgments. There are 6 or 7 paragraphs. I would request your lordships to have a look at that. My lord, this is in Roman part 4, put it in the 4th one. This we can leave. I have given references to the statement of objects and reasons of each of the acts, 96 Act, 2015 Act, 2019 Act, what are the relevant? I'm not going into it, it's there in the note. I'm curtailing this. Your Lordship will straight away come to the 246 Law Commission. And please note, my lord, in this volume, pages 22 to 27, 49 to 51, and 52 to 55.
volume.
Oh,
Oh, just
Both.
repeat these pages once.
22 to 27, the main discussion, 49 to 51, and 52 to 55. Because this is the legislative background to the bringing into existence of 11. My Lord Justice Rastogi has got this volume.
We have volume 4.
Volume 4. My Lord, it's the report starts on page 1, and the relevant pages are 22 to 27, which are the main pages. My Lord, 22 starts. I'll just read a few portions, my Lord, just to put this in perspective. Delays in court before the arbitral tribunal investment treaty race. My Lord, this refers to that White Australia case. Judicial intervention in arbitration proceeding adds significantly to the delays in the arbitral process and ultimately negates the basis of arbitration. 2 reasons can be attributed. First, the system is overburdened with work, not sufficiently efficient, disposed cases, especially commercial cases, speed and dispatch. My Lord, this is really a reason which is beyond my Lord, us at the moment. Secondly, the bar for judicial intervention, despite the existence of Section 5, the Act, consistently been set at a low threshold by Indian judiciary, translates into many more admissions cases in court arise out of related acts. So, my Lord, 22 identifies 2 problems. 23, your lordships will skip, which is the wider problem. My Lord, we are not concerned with this at this stage. 24, 2 further sets of amendments proposed. First, it is observed a lot of time is spent for appointment of arbitrators, very threshold of arbitration proceedings. Applications under 11 kept pending for many years. In this context, Commission has proposed a few amendments. Commission has proposed changing the existing scheme of the power appointment being vested in the Chief Justice of the High Court and the Supreme Court, and has expressly clarified that delegation of power appointment as opposed to finding regarding existence nullity shall not be regarded as a judicial act. This will rationalize law and provide greater incentive to the High Court to delegate the power appointment to specialize. So, my Lord, this is one recommendation. 11.7 recommendation, my Lord, is also there. Then your Lordships will come straight away. So, this is by way of background. My Lord, the main paragraphs are 28 to 33. These are, my Lord, extracted in Mayavati also. But there is one paragraph, according to me, my Lord, 29 is the critical paragraph which will address large number of issues. May I read 28? The Act recognizes situations the intervention of court is envisaged at pre-arbitral stage prior to the constitution of the tribunal, includes section 8, 9, 11 case of part 1, section 45 in case of part 2.
Which one you are reading?
My Lord, para 28 at page 20.
Yes.
Yes. So, my Lord, it recognizes situations the intervention of court is envisaged at pre-arbitral stage. Sections 8, 45 and also section 11 relating to reference to arbitration appointment are directly affect the constitution of the tribunal functioning the arbitral proceeding. Therefore, their operation has a direct and significant impact on conduct of arbitration. Section 9, solely for the purpose of securing interim relief, although having potential to affect the rights, does not affect the conduct of arbitration in the same way. It is in this context, Commission has examined deliberated work. Now, my Lord, 29. I rely on 29 as an understanding, my Lord, of all the provisions. The Supreme Court has had occasion to deliberate upon the scope and nature, italicized, of permissible pre-judicial intervention, especially in the context of Section 11. Unfortunately, however, the question before the Supreme Court, framed in terms or whether such power is a judicial administrative power which obfuscates the real issue underlying such nomenclature description as to the scope of such powers, i.e. the scope of arguments which a court oblique Chief Justice will consider while deciding whether or not to appoint an arbitrator, i.e. whether the arbitration agreement exists, whether it is null and void, whether it is voidable, etc., and which of these it should leave for decision of the tribunal. So, my lord, first, scope. What is the scope of 11.6? Second, my lord, what was put to me by my lord, Justice Ravi Kumar, nature of such intervention. Would the court consider the issue on a detailed trial, whether the same should be decided finally or left for determination? So, my lord, these are conceptually two issues that your lordships will have to decide on 11. What is the scope, which is what we are actually concerned with. We are not concerned with, my lord, the second portion of nature of intervention. What is
32 and 33 you have read? Look, better.
30? No, no, I have read only 30, then 32 and 33.
Please read that one.
32, I'm reading that one. I have only come to 29, my lord. Then after a series of cases, Supreme Court held that the judicial power underlying issues were clarified by Bogara. So, my lord, then 30 Bogara set out. Commission is of the view that in this context, same test regarding scope and nature as applicable in context 11 should also apply 8 and 45, since the scope and nature judicial should not change depending on party intending to defeat arbitration agreement, refuses to appoint an arbitrator, terms of the arbitration, moves the proceeding before judicial authority. In relation, my lord, this is to answer the question which fell from the tribunal. In relation to the nature of the intervention, the exposition of the law is to be found in the decision of the Supreme Court in Shinetsu versus Aksh Optify, my lord, 2-1 judgment, context of 45, where the Supreme Court has ruled in favor of looking at the issue controversy only prima facie. Justice Sabharwal, Sri Krishna took a view, and there was a split verdict. It is in this context, Commission has recommended amendments to the Section 8 and 11 of the Conciliation Act. Scope of judicial intervention is only restricted to the situations where the court judicial authority finds that the arbitration agreement does not exist or is null and void. Even this was not accepted by the legislature. Even this was not accepted. The legislature cut out null and void. It went one step further and said existence. But I actually, my lord, personally, my submission is that there is really not much difference between existence and validity. It may be that the word existence may also in some way cover validity. It is not merely that your lordships will see on a piece of paper an agreement is there. Maybe some inquiry will have to be there. Is there some consideration? Is there something will have to be said? So, my lord, the recommendation was exist, null and void. Inoperative, incapable of being performed, not included. So, existence and null and void. Similarly, my lord, insofar as nature of intervention is concerned, recommended in event court is prima facie satisfied against the argument challenging the arbitration, it shall appoint the arbitrator, refer the parties to arbitration. Amendment envisages the judicial authority shall not refer only if it finds that it does not exist in arbitration agreement or it is null and void. If the judicial authority or the opinion prima facie arbitration agreement exists, shall refer the dispute, leave the existence to be finally determined. However, the judicial authority concludes the agreement does not exist, conclusion will be final. So, my lord, this was the understanding in Shinetsu, and this is how it was. And, my lord, the amendments which were suggested are there. So, this is, my lord, the critical part of the report is paragraph 28 to 33.
Para 10 also, para 10 of we are reading Mayavati actually.
Oh, your lordship is reading Mayavati.
So,
I am reading it from the report, my lord, because
it is incorporated in the.
my lord, para 8 to 14 of Mayavati actually summarizes it. But interestingly, my lord, one or two of these paragraphs are not mentioned in Brolia. So therefore, my lord, I read it from the.
Therefore, the trick lies really in the manner in which both you approach it and how you couch the order.
How you couch the order.
If you say that there are contentious issues, we are not fully satisfied, but there is prima facie an agreement, say so, leave it to the arbitrator. Fine.
Good enough. So, my
Not
lord,
matter.
fortunately, my lord, we are not on existence today.
And
Because
we are on
the larger issue.
way out instead of
We are on not even we are on stamping, my lord, which is one larger area. My lord, we have gone past existence, we have gone past validity, and we have got to admissibility. So, my lord, today we are debating what is to be done.
stamp.
Stamp. So that is in fact my lord, there can be no dispute. I say this with authority, my lord, that an unstamped agreement exists and is valid in law. My lord, they cannot be disputed that that transaction is a
We
valid.
repeat yesterday's question, whether under section 35 of the Stamp Act or 34 of the Maharashtra Act,
34 and 33, 35 I have to answer, my lord.
whether it amounts to adducing evidence when when an applicant in section 11 produces the agreement, whether it is adducing evidence, whether it's in that sense it is straight away attractive.
My lord, whether 33 and 35 are attracted or not. My lord. Can I, my lord?
First of all, in section 11 application.
Yes, your lordship had asked me that question, my lord. You produce the document.
Yes.
Is that admission into evidence or not? And
That's
whether
the only
as a result of that, 33 and 35 engage.
That's the only issue.
Right. My lord, I will go one step behind that and I will say that 33 and 35 is not at all triggered. And I will show, my lord, how 33 and 35 is not triggered, my lord. So, my lord, this is the 246 Law Commission report. I have also set out, my lord, in the note, the relevant pages of the high-level committee. This is Sri Krishna committee, my lord. I am not going to read it in the interest of time, my lord, but that is at page 84 to 87 of this volume. The report starts at page 75. The relevant paras are 73 to 76. My lord, it is in the note. I am not reading it out. It doesn't advance matter much further.
Yeah.
But it also says that SBP has been overruled. You have to consider the aspect of speed, etc., etc. In fact, now under the new regime of high-level committee, the courts are completely excluded from the appointment process.
Yeah.
There is a complete exclusion of courts from the appointment process. Courts will come in either at 16 or 34 stage to, my lord, give the final stamp of approval or rejection. So it's not that the courts are excluded. The intervention of the court has been, my lord, shall we say, deferred, or the application of mine and detailed understanding of the courts has been deferred, my lord, to a later stage. Because that is, my lord, how the legislation is structured. That first you go to the arbitrator and decide, and questions of jurisdiction, those 4 headings, my lord, I'd shown, whether it is subject matter arbitration, etc., all will go there. Now, my lord, 3 judgments. Your lordship is looking at Mayavati. May I just show the other 2 judgments before that? My lord, Duro Felguera. Please see Duro Felguera.
Which volume?
My lord, volume 2.
It's at page 64.
Duro Felguera
There are page 64.
Yes.
of it.
has been approved in Mayavati specifically. So, my lord, I just want to show the reasoning. So, Duro Felguera begins at page 64. My lord, the merits of the matter are really not much of consequence here. I have put it out in the note. There was a supplementary judgment by Justice Joseph, Korean Joseph, of which 4 or 5 paragraphs are important.
Yeah.
Because they have been approved, and that is the approach which has now been accepted. Justice Korean's judgment starts at page 94.
That is the first judgment.
Sorry,
That is the first judgment on 6A.
that's the first judge. That is the first judge, Your Lordship.
6A has been interpreted in number of judgments
Right.
in a different way.
Right.
That is for the guidance.
This is the first one. First
We are only on the limited issue.
Stamp.
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 If it is unstamped, insufficiently stamped, what will be the scope
Right,
for the code under section 11?
right,
So let us confine back to that.
right. So, my lord, I am saying that this is
But
the
it's
test
on
on other things.
multiplying on a different.
I know.
context which
I
is
agree.
required for us.
It's not. It's not
Otherwise, this is an unending debate.
unending dispute. My lord, I will
And,
go
more the discussion, more
More
the
interesting points.
opening the questions to be answered.
Right.
So we confine back to this.
Stamp.
Stamp back.
Stamp. So, my lord, I am showing this only in the context of stamp.
Yes.
I am showing, my lord, 3
But
judgments.
that was not the case in reference to Stamp Act.
No, my lord, but the proposition which was approved is the proposition which will apply even for stamp.
Yeah, 52, 53. something.
Yes, my lord. I'm saying that's the test. Please apply that test. That's what I'm saying, my lord. It is not on stamp. But my lord, it gives the test.
Same problem comes in. Suppose it's just sitting in 482. It's just sitting in a criminal revision. Scope is different. But the parameters when we test, it's not overlapping. And judge is sitting in 226 and 227, and judge is sitting in 227. Parameters are quite different.
Correct.
But when we, as a judge, when we said
Correct.
almost the same parameters go on overlapping,
Right.
and a lot of confusion goes on. The scope in 226 and 227 and 227.
Correct.
Goes.
So, my lord, I am only showing this. Therefore, I said, my lord, I am not going to the facts of this case.
Para 59 is what you want to.
My lord, 3 paragraphs.
Para 59.
4 paragraphs, my lord. I've noted the paragraphs, my lord. First, he starts, my lord, after analyzing 47, 48. My lord, 48 is referred to in Justice Nariman's judgment at page 94. That's why I'm mentioning.
59 is what is important.
59 is important. My lord, 56 says that this is the one of the first cases. And my lord, 59
59 is sufficient.
is sufficient.
That's what we.
59 is sufficient. So, my lord, I rely only on 59. 59. The scope of power under so-and-so was considerably wide in view of the decision of the SPP. Position continued till the amendment. After the amendment, all that the courts need to see is whether an arbitration agreement exists, nothing more, nothing less. The legislative policy is essentially to minimize the court's intervention. And intention ought to be respected. This is, my lord, according to me, nothing more seems to be relevant. Thereafter, my lord, the next judgment I've referred to, my lord, I've referred to in my note, my lord, is Uttaranchal Pur Sainik, which, my lord, which also deals with this aspect, 2 paragraphs there, and then straight away my Uttaranchal Proof Sainik is in page 127. This is, my lord, I believe my Lord Justice Rastogi was also a part of it. Page 127. No, really, the relevant paragraph is 7. This starts at page 127 of this compilation. It's 2-judge bench. Paragraph 7, my lord, really deals with the issue, because the issue there was whether limitation should be gone into or not. But, my lord, what is important is, I have mentioned the paragraphs. It gives the history of 2015 amendment, etc., etc. And then, my lord, 7.7 Law Commission report, and 7.8 it relies on Duro Felguera, and, my lord, 7.10. In view of the legislative mandate contained in 11.6a, court is now required to only examine existence. All other preliminary or threshold issues are left to be decided by the arbitrator under 16, which enshrines the competence. And then, my lord, 7.11 explains in some detail the competence principle, and said it is subject to the court's control. It is not that it is completely the arbitrators like tilting at windmills can do whatever he wants. There is some court control. And, my lord, 7.12 is also important. The legislative intent is party autonomy and minimal judicial interference. Also at the pre-reference stage is also emphasized on 7.12 and 30. No, this is a little more elaborate. And then your lordship comes to Maya. 115, which your lordship was, my Lord Justice Joseph was already looking at. My lord, this case also was not a stamp case. It arose out of accord and satisfaction. And, my lord, the importance of this case, if I can say, is that it sets out in one place the legislative history. So it can easily be, my lord, paras 8 to 14 set out the legislative history. The finding of the court, my lord, before your lordships see the finding, please note paragraph 10, the legislative overruling of SBP. My lord, please come to para 10, 125. This being the position, it is clear that the law prior to the 2015 amendment that has been laid down with this court, which would have included going into whether a court of satisfaction takes place, has now been legislatively overruled. This being the position, difficult to agree with the reasoning concerned in the aforesaid judgment. And as section 11(6)(a) is confined to the examination of the existence in italics of an arbitration agreement and is to be understood in the narrow sense as laid down in the judgment in Duro Felguera at 48 to 59. So, my lord, these are three general judgments, my lord, on the scope of 11(6)(a), apart, my lord, from Vidya Drolia, which I will deal with separately. So, my lord, with this aspect, I'm not going to show World Sport Group, my lord. I mentioned World Sport Group. World Sport Group was a case under section 45. And in World Sport Group, three separate expressions were defined: null and void, inoperative, incapable of being performed. So, my lord, a non-stamped document at the highest may be incapable of being performed. At the highest. Even that, my lord, may not be correct because it's a curable defect. But it is certainly not null and void. My lord, in fact, this phrase null and void, which is used in part 2, is actually only void. Null and void means void. This is in the English text, it is null and void. In the French and Spanish text, my lord, it means void. So if an agreement is void, then perhaps, my lord, it will go to validity. So, my lord, there is narrow existence, then there is validity, and, my lord, thereafter admissibility. So, my lord, we are at stage 3. So, my lord, existence, certainly it exists. I would say that a unstamped document is also valid, i.e. it is not void. So, my lord, so far as 11(6) is concerned, 6A is concerned, one word I would like to emphasize, my lord, which is confined. The language of 11(6)(a), my lord, I understand that after the recommendations of the Law Commission were placed before the government, my lord, there was some rethink and 11(6)(a) was rejigged. And the expression is, first word which is used is confined. And confined, your lordships will note, Lord, we have mentioned some dictionaries, etc. Confined means circumscribed. Confined means, well, not Lakshman Rekha. Confined means that it is within that limit. So the 11 court will have to confine to the examination of existence and nothing more. So, my lord, this is also part of the legislative policy.
When we come to section 20 of the contract,
20 of the contract. Not voidness.
voidness.
My lord, none of the section from 20 to 30, which includes contracts which are void, cover an unstamped agreement.
That's right. We are asking you for some other purpose.
Right.
Supposing a contract is alleged to be void as distinct from voidable.
Void ab initio.
Void ab initio.
Void ab initio.
If an agreement is void ab initio, can it exist?
My lord, there is a little gray area there. My lord, two words have been used. One is existence, one is validity. According to me, my lord, it may existence may encompass validity also. So, my lord, it may be argued that existence includes validity, though the legislature has used two different words.
What will be the effect of the contract being declared voidable under the Contract Act? Because
those are the next few sections, my lord. That is an option which is open, my lord. I'll show those sections of the Contract Act.
Would a voidable contract, can it be said that it exists?
It exists, my lord. It certainly exists.
It exists.
It exists. So, my lord, subject to the contract being void, my lord, and therefore, at least in my note, I have, my lord, submitted that formal validity will have to be established to some degree before the 11 court. You will have to, at least as an 11 judge, see whether you know their basic ingredients are.
You got a finding finally.
My lord, then we are back to
You got a finding.
then, my lord, we are back to the other question.
Yes, so ultimately, 11 court. 11
my lord, then we are on the standard. My lord, one is scope, one is standard, my lord.
a sort of nebulous area.
you then.
You say leave it,
But, my lord,
but it should be left open. There's a whole problem arises where
if it's not left open,
if it is not
if it's not
left open.
yes, absolutely. That's the only way really to reconcile 11 and 16. It'll have to be left open. Otherwise, my lord, then whether one likes it or not, a court is a court, my lord. Then an arbitrator will be very chary of however much we say that Article 16 is very wide, give it its full play. No arbitrator will really then want to revisit what a court has done. That's the practical implication. Triple right. Well, I just it's not in the compilation. I'll just tender this for the purposes of completion. We mentioned it at page 23. The word confined, what it means. Wait. Second last entry on the right column. To keep within circumscribing limits, to restrict. Just, my lord, it's just an understanding of the movement. As your lordship said in the other matter, one has to confine to only, my lord, the guidelines. Here I have to confine only, my lord, to stamp act.
Once made, we have to remind ourselves that while deciding applications of section 11 is not a court.
It's not a, my lord, full-fledged court of record in the way that your lordships are today.
So this back of the mind goes on all the time. That sometimes creates a lot of problems.
And, my lord, the instinct of the judge is to decide. If the judge sees, my lord, there is a lot of criticism of our courts that we are intervening. Lot of criticism. But, my lord, my personal view, and I want to make this clear, is that the reason that the courts are intervening is because there's serious defect in our legislation in the Arbitration Act. We have eliminated 16 appeal. We have, my lord, not looked at 34 properly, my lord. There are any number of reasons where the courts are intervening because we have not got the proper statute. So it's very easy, my lord, to blame courts because courts will interfere or intervene if there is injustice.
One suggestion which I heard was when a court deals with section 34, the court should not be burdened with the obligation to furnish reasons.
Permit?
Furnish reasons. So what is happening is
That
told that in all these courts, matters are pending for long periods of time where you hear elaborately something like the SLP jurisdiction.
my lord, it should be a
When you
shorter
say
order.
dismissed, that's it.
But, my lord, if the High Court start passing shorter orders, your lordships will say, and 136 or 37, my lord,
37 itself.
yes, my lord, please see the section 11 orders which are coming to my lords. They are all 30, 40 pages. Because the High Courts have to write such an order to show that I have conducted, quote unquote, an
Application of mind.
intense yet summary estimate of section 11.
And when the party places a
But
document
we are
of
all-
1,000 pages,
We are all
and
responsible.
then you ask the district judge or the assigned officer, look into those 1,000 pages and report the application of mind. God knows where the application of mind will come
What happened?
in deciphering 1,000 and more pages.
You don't have.
That's the issue.
And then in 37, it's all scope. If you are not assigning reasons in 34, 37 is open.
My lord,
And the court has no business except to remit the matter back to the district court.
and then, my lord,
Because now it is not possible.
the other problem is we have only ad hoc arbitration. We don't have institutions and we don't have, my lord, institutions which we respect. So normally in other jurisdiction, if the institution is respectable, then you look at it and they have also had a look at it, then you don't really want to interfere, you can, my lord. But today we have so many very peculiar awards also. My lord, one has faced them where you know that there is something that is not.
That is something we look into 136, who is the judge who has passed the order. But that is not the way it was. That is not an advisable situation. You have to look into the merits, not the author. But we look into.
Now, my lord,
This, one more question.
One
I
more.
just wanted to, when we saw it, if this come to section 35.
35.
That was the question which we troubled you with,
Yes, please.
namely whether its purpose is actually to deal with the aspect of adducing evidence.
Right.
There is another aspect. to it.
Right.
This is
Yeah.
section 35 one stop here.
Well, could I address your lordships on 33 and 35 now?
There you can.
So that will
But
not
we just wanted you to
Yes,
read this.
35, yes.
Specific issue
specifically.
because it's important to the question at hand.
Yes.
You just read that.
No instrument chargeable to the duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered or authenticated by any such person or by any public officer, unless such instrument is duly.
So the question is, it actually interdicts to receive, authority to receive evidence, nor shall be acted upon.
Correct.
Now, when section 11, under section 11, now,
Are you acting upon it?
are you acting upon
Right.
it? At
No,
least.
At least acting on. My lord, that this is my lord, my response, and I'll give it now, my lord, because I can understand that 33 and 35 is certainly bothering my lord. I'll give a response, my lord, not on the larger plane. I'll give a response on the sections. My lord, the section triggers. 35 only triggers if there is a finding that the document is not duly stamped. So, my lord, after the comma, unless such instrument is duly stamped. So, my lord, there has to be first an inquiry as to whether ABC document is duly stamped or not. Or am I making myself clear?
No, the point is, we were actually, stuck up with the concept of admissibility, inadmissibility, flowing from section 35. But we thought that it goes a little further. Section 35.
Or acted upon.
Or acted upon.
Yes, my lord, it goes further. No doubt about it. No doubt. My lord, they are two independent limbs.
So then the next question.
I'm answering the question in a different way.
No, then the next question will be, the theory of unenforceability,
My lord,
which you took exception to.
Yes.
You said an arbitration agreement is very much enforceable.
My lord, I say it exists.
It exists.
It exists.
No, it exists.
It exists.
But can it be enforced if it cannot be acted upon?
My lord, it enforceable.
And when you talk about acted upon,
My lord,
it must be
enforceable at
understood-
law.
It should be understood as
My lord,
acted
that
upon
phrase.
in a court of law.
Enforceable by law, my lord, is a phrase used in the Contract Act. I'll come back to that, my lord. Please, there's a very interesting, my lord, there is a particular part of Justice Nariman's reasoning which goes on the phrase enforceable at law. So, my lord, I'll come to that. But I have a different answer to 35. I have a very different answer to 35. My lord, 35 will trigger. 35 is a bar. It's a bar, my lord. It's a bar. Subject to exception, my lord. I'm leaving this. It's a bar, my lord. 35 is preceded by 33. 33 is, in a sense, the same side, other side of the coin. So when the document comes, there is a duty on the judicial authority or the arbitrator to look at the document and make an inquiry. The sequitur is that if the arbitrator or the judge or anybody finds that it is not duly stamped, he can't even act upon it. So, these are two parts of the same legislation. So, my lord, the bar comes because, my lord, so 35 is the bar and 33, my lord, your lordship, go back to 33.
Let us put it slightly differently. When a person, without taking care to get it impounded, without paying up the duty with the penalty, he rushes to a 11th port. He rushes to 11th port with an unstamped or insufficient.
Unstamped. No, let us take unstamped. Unstamped.
Unstamped. And no doubt about that it is a document, is an instrument.
My lord, that's where the doubt is, my lord. Your lordship said no doubt about it. That is where, my lord, I have.
No, you have yourself said.
My lord, I'm answering myself, my lord. Your lordship.
Because I see, yesterday you said an agreement to refer, even if it is a separate independent agreement, has to be stamped. So we begin with an unstamped agreement.
My lord,
an
I go
instrument.
one step
What
back.
you're saying is something different.
I'm
The simple question is, can you
Act upon.
actually act upon?
My lord, I'll answer.
Will not the court be said to be acting upon?
Right.
Forget about evidence.
I'll answer it. My lord,
Forget about evidence.
forget about it. Forget about it.
Very act of referring to the.
My lord, I have an answer on acting upon it. I'll come to that. But my lord, I have a preliminary point, which is that please see 33.2. Please see 33.1, 33.2, and then 35. And I'll explain, my lord, why 35 bar is not even reached. No, 35 bar has to be reached. 33.1 says, every person having by law consent of parties authority to receive evidence, every person in charge of public. Now, this is the same language as 35. Except an officer of the police before whom any instrument chargeable in his opinion, which duty is produced or comes to the performance of one, shall. Now, my lord, these are the critical words. If it appears to him that such instrument is not duly stamped. Now, my lord, the examination by the person is to examine whether such instrument is duly stamped or not. That examination is found in, my lord, 2. For that purpose, every such person shall examine every instrument so chargeable and so produced before him in order to do what? In order to ascertain whether it is stamped with a stamp of the value and description required by the law enforced in India when such instrument was executed or first executed. So, my lord, if 33.2 is triggered, then 33 will follow. And if, my lord, if I have to conduct this examination, I will come to a conclusion that it is not duly stamped. And then if it is not duly stamped, it will be barred. So, my lord, steps are different. We have jumped 3 steps. So, my lord, my submission is that 33.2 examination is not to be done in 11.6. That's the submission. So, if 33.2 examination is not to be done in 11.6, my lord, neither will 33 apply nor will 35 apply. 33.2 examination is to be done, yes, by the arbitrator. So, my lord, it is not that this is being escaped, but this examination, if you are not required, but therefore I come back to scope of authority. It is not within the Lakshman Rekha or scope of authority to undertake this examination. Because, my lord, if your lordships do undertake this examination, I have confidently today told your lordship, it is arbitration agreement is to be stamped. Till yesterday, my lord, there was a 3-judge bench judgment of this honorable court which said arbitration agreement has not to be stamped. Today, there is a controversy inter parties on what is the value of the stamping, what is the person to be paid, what is the dispute. So, my lord, if 35.2 is to be done by by the 11 court, the bar in 35 will hit me. But 35 bar will not be triggered because 35 will not apply. That's the submission.
Can you not harmoniously interpret 11.6a with section 35 as we are duty bound to do? Both are central enactments.
My lord, 35
No,
first.
are we either we close our eyes completely to 35?
Your lordship is not closing eyes to 35 completely.
We are not.
You are only deferring it.
No.
You are not, my lords are not closing eyes to 35.
The point is that we are bidden to not act upon the document
Unless it is duly stamped.
unless it is duly stamped.
But how?
It is stamped to begin with.
No, my lord.
Duly
It says
stamped is okay.
it is
In a
duly
case
stamped.
In a case where there is no dispute that the document has to be stamped, number one, we are taking that case alone.
My lord, then we are now going beyond the existence of the agreement.
No, that we are telling you. See, when 11.6a was enacted,
Right.
it was enacted with a particular purpose. What was the legislative history, judicial history, SBP, 7 judges, earlier
My lord,
judges?
the purpose.
They were going into 3 categories of cases. They thought that all of this is covered under section 11.
Right, my lord.
So actually they trimmed the jurisdiction, as it were, and said you have to only look into the existence of an agreement.
Now, my lord, by looking at into the
Now,
existence of
existence of an
existence, my
agreement,
lord.
existence of an agreement,
Right, my lord.
which we have to also bear in mind on in the same breath, we have to also say that it has, we have to act upon it.
My lord, your lordships are assuming that that bar is there of acting upon.
That's right.
I am saying that that bar, my lord, it is like a you have not even reached the point. My lord, this 35 will trigger only, my lord, because this expression duly stamped, my lord, has been explained in 214. It is not stamped, unstamped, my lord, it is duly stamped. So, my lord, if it is duly stamped, then there is no bar. It may be in cases, my lord, a document may not require to be stamped at all. I have given an example. So, my lord, the question is, will this court, or not this court, my lord, the 11th court, be required to make that inquiry? Yes, if your lordships feel it is required to make the inquiry, what are the consequences which follow? That is certainly one view, my lord. But having used the word existence, having, my lord, curtailed it from admissibility, validity, existence, my lord, confined. It is confined, my lord. It is a list which has to be ticked off. Valid agreement, my lord. If it is not then the word meaning of the word, my lord, confined will go.
See, the validity of the agreement, no difficulty.
So, my lord,
You have to not confuse an unstamped agreement with an invalid agreement. It is not. You're right.
right, my lord.
In
So
that
moment
sense,
it is
not,
valid.
It is not an invalid agreement. It is.
It's a valid agreement, no?
It takes a valid agreement.
It's a valid agreement.
No, what you're saying, it is a valid agreement.
It's a valid agreement.
It exists.
It exists.
It exists. It's
Right.
not as if it is void.
It's not void.
Both of that, you're
So far, so good.
The question is, when the court, when section 35, which is equally the mandate of parliament,
No, no, 30,
says that don't act upon it
unless stamped.
unless it is stamped.
No, no, but unless it is stamped is an issue which has to be decided.
In a case where,
My lord,
in a case where
that's a
nobody has
presumption, my lord.
in a case which we are giving us, that all these, because the three judges bench which is referred, it is wrong in saying that an arbitration agreement.
So, my lord, that's the issue, my lord.
If it is completely unstamped,
My lord, that is
there is
the
no
issue.
dispute about it.
That is, my lord, that is the issue, my lord. The question is, your lordships are therefore assuming that 35 is complied. I am saying you have to look at 35 and you will have to look at 33. I'm coming to acted upon, my lord. On the phrase acted upon, my lord, how that works. I'll come to that, my lord. My lord, also your lordships will have to keep in mind, my lord, Stamp Act is 1899 when we had an 1899 Act, my lord. We have progressed considerably with the arbitration. There have been 1899 Arbitration Act was there. Lordships will have to give some interpretation which will make both workable.
Exactly.
Right? Now, my lord, I am suggesting that the only way or the practical way to make both workable is to leave this decision of stamping good, bad, indifferent, high, low, whatever it is, to the arbitral tribunal. Who has the power? There's no dispute he has the power. The sections say so. And he has to obey the law. So, my lord, the other view is, let's test the other view, my lord. The other view will necessarily mean that the legislative, my lord, intention of appointing an arbitrator merely on the existence of an agreement, whether prima facie final or whatever it is, and limiting the scope of the authority will go for a toss. Now, that's the reality. That is what had weighed, my lord, with the full bench and my lord, and it is not our say so, it is the legislative history and the reason for bringing the amendment through. Today, my lord, who is raising this question? Let's put it a different way. Who is raising the question of non-stamping? The person who does not want to go to arbitration. It may be that he has to pay the stamp, but he doesn't want to go to arbitration. So, my lord, or take my lord, case where you want, which we are not concerned with, the interim release, section 9. We are not concerned in this case. Who is raising the non-stamping defense, my lord? And how do we balance it? Do we, my lord, put a chokehold at the stage of 11.6 when 33 and 35 can be equally, my lord, read, my lord, I ask myself a simple question. Is the 11-6 judge required to do 33-2? Is he required to do this or not? If he is required to do this, my lord, this will go against 11-6. If he is not required to do 33-2, then 35 will not even come into the picture.
So according to you, the conundrum is only this. Who is to decide?
That's all, my lord.
Who is to decide? And according to you, the section 33(2) of Stamp Act, that examination need be done only at the stage of first 16 by the arbitrator.
Not at the stage of 16, my lord. Right at the beginning. He doesn't even have to go to 16. He has to do it on virtually.
By the arbitrator only.
Yes, on day one. Because, my lord, moment you have an unstamped agreement, none of the substantive rights can really
In
be
short, 33(2)
33.
32 are examined only by the arbitrator.
And that will work well, my lord. It will work in every way. It will work. The revenue will be protected. The document will be impounded. The decision will be there, subject to court control. There will be no delay. Why should, my lord, I put it in a different way. Why should the court burden itself with this headache? Unless your lordships interpret as this is a gun to the head, you have to do it. So, my lord, that's the question. Why should the court burden itself?
Do it completely, complete circle. Because we accept your contention.
Right.
And we also find prima facie what to say is workable. And is a speedy
Right.
disposal of the applications and let the parties come to arbitration. Ultimately, what will happen? From our 11th jurisdiction, it will transfer to the jurisdiction of the arbitrator.
Yes.
Now, obviously, in the written statement, that will come forward, the first objection would be unstamped or
Yes. Yes.
insufficiently stamped.
That will be fought out.
Now they will say you can't proceed, must get an inquiry of 33 to
No difficulty.
and then 35
No
and
problem.
thereafter, meaning thereby, then what we are going to hold and record a finding will be stuck by the arbitrator and then he will take another.
No, your lordship will not record a
I-
finding.
No, no.
Your lordship will not
No,
record
we are not
anything.
saying. Suppose if we take an inquiry
Yes,
and
ma'am.
record a finding
Right.
in reference 33 or whatever it is and say, no, no, sorry. Whatever the document is, it's fully stamped, nothing doing. That chapter is over, let the parties address the merits before the arbitrator. There's one theory.
One theory.
The second theory, as you say, is sorry, you don't intervene in section 11 jurisdiction. Leave it to the arbitrator to examine. All right. We agree. Now, the first question would obviously the person who doesn't want to go for arbitration
We'll raise it.
will raise it
My
definitely.
lord,
raise it.
three things will happen.
Same man. So,
Aren't we coming to the same conclusion? Is what your lordship is saying.
we are on different point. So, when the matter is now instituted before the arbitrator and the person who is not inclined to go for arbitration,
We'll raise the point.
definitely raise it.
Definitely raise it.
Obviously. Now, the arbitrator will also extend the exercise. Yes,
He will have to undertake the exercise.
To 33.
Yes, my lord.
They do inquiry and then 35 as to what should be adequate
Penalty,
stamp or whatever it is.
penalty, stamp,
Now,
whatever.
now the legislature also says simultaneous. Arbitrator should also
Right, my lord.
within 1 year plus 6 months from service and all.
No difficulty.
Now you will find in the system which we are today privileged, the arbitrator will be stuck to proceed unless that document in reference to which the arbitration proceedings are to commence is not being properly and adequately, insufficiently or sufficiently
My
stamped.
lord, I am doing some arbitrations like that. I'll explain, my lord, what happened.
So,
I've
what
seen that.
to us, subject to what? Are we not to step in or leave it to the arbitrator to
My
make a call
lord,
and
let's
do it in his own way?
let's play this out.
Or
Should your lordship not decide it?
not decided?
So, my lord, let's play this out. Supposing this very point of unstamped is raised before my lords, right? My lord, in practical terms, this, my lord, one is the interpretation of 3335. In practical terms, what has happened, my lord, and I can vouch for this, Delhi is taking a different view. In Bombay, virtually everybody is raising this as the defense. So you file a reply, then you file a rejoinder, then you hear the matter after a year. No, this is the practical reality.
That's correct.
This is one version, my lord. So the arbitration is stuck. You've not got an arbitrator yet. The other, my lord, option which I am suggesting, because I am appearing in some such arbitration, where there is no dispute here, my lord, there is no section 11. You straight away go before the arbitrator, the other side has raised the point. My lord, two or three things have happened. Either the arbitrator has taken the point, you file your reply, I will decide within a week. Right or wrong, I will decide. Whatever I decide either you are liable, he is liable, or I decide it is 10 lakhs or 5 lakh. That's also a dispute in the arbitration itself, because you can pay and recover, my lord, in the arbitration itself. So one stop, my lord, solution. Secondly, my lord, what happens in some cases, once the arbitration starts, one or other side simply pays it and then adjusts it at the end in the award. Many cases before, my lord, one case, the petition has been withdrawn because people have, my lord, because it has been pending, they've simply paid and got along. Like in this case, my lord, they have overpaid according to that. So, my lord, which is the better option? Should this court be required in law or otherwise to decide this? Because, my lord, always the court wants to decide every point, or leave it to the arbitrator where this will be played out at least faster, and it will come out of the system. It may go back into the system later in 34, but it will come out of the system. My lord, ADR, my lord, we are now speaking of international arbitration, hub of arbitration. If your lordship sees some of those articles, particularly one which is written, the sort of language which is used, my lord, my blood was boiling, but I put it there. My lord, there are, if we overextend or increase the ambit of 11, there is my lord, an issue much above and beyond. My lord, your lordships are restricted to stamping, but if a constitution bench takes the view that 11 includes, my lord, stamping, then it may legitimately also be argued it may include limitation, it may include X, it may include Y, it may include Z. Where does one draw the line? So, my lord, that is why, my lord, I am advocating the nano mean. And that is why, my lord, I am advocating that 33 and 35 actually does not trigger. My lord, on acting upon, there is a, my lord, there is another argument. There are, one of the articles, my lord, deals with this acting upon thing, which Mr. Rebello has written an article. My lord, he has dealt with it in some detail in volume 4 on this acting upon aspect. But, my lord, my understanding is that this is not an inquiry you should undertake. You should not even say what I am saying, what I said yesterday, that this is wrong. I had to say it is wrong because the judgment is wrong. But it is not something you should be looking towards. You should not be looking towards stamp. It's not your headache at the moment.
One thing, it is a jurisdiction for the arbitrator to decide how to proceed. Because the law of evidence is not applicable.
Law of evidence. But, my lord, in fairness to this, the arbitrators enjoined by section 35, because he is named as a party by consent. So he will have to look at it. He cannot avoid the substantive law.
No, but the law of evidence is such not applicable.
Law of evidence is not applicable. 19, lordship is right, law of evidence is not applicable. But he will have to look at it. Well, I'll give an extreme case. Both parties go. The document is unstamped. The arbitrator still has to look at it, because it is his duty to protect the revenue. Supposing neither party raises it, it happens. Or if he ignores it and it's taken in evidence, under 36 it is waived. It's a curable defect. It's not a big deal, Mano.
I mean, you're rejecting a disputed case for as a premise for your argument.
My lord, I am suggesting all cases are disputed because
Supposing the party who's an applicant under section 11 himself admits, yes, it is unstamped. It really doesn't bear the stamp it should. He admits, he doesn't say he has absolutely no case. What should the court do under section 11?
my lord, if he admits, then he has to pay the stamp duty, my lord. That is on admission, my lord.
Exactly.
But admission will not make, my lord, the. But then the question is, my lord, should he be at all asked the question?
If he volunteers,
I don't think, my lord, anybody volunteers anything, my lord.
It can
But
be other way around also.
you have to ask the question.
Either to pay tax or.
You will say, all right, I volunteer to have a stamp of 20 rupees.
No, no,
And
other
then
side, other side objects.
Others, my
Side
lord.
objects, and he says, yes, it's correct.
So right. But is the judge required to ask himself this question? Answer, my lord, if he is, 33 and 35 may have some conflict. If he is not, then my lord, that's why it is a very limited jurisdiction. You see agreement, you see, my lord, I'm sorry, the Hindi motor.
Answering the question. If it is unstamped, what kind of 33 to inquiry is required? If insufficiently stamped, you need inquiry. But if it is not stamped, then what 33(2) inquiry you want?
My lord, I'm saying that
No dispute at all.
Lord,
That is this-
What kind of 33(2) inquiry you are asking for?
I am not asking for the inquiry. I am saying that you please don't get to the 33(2) stage. Your lordship is assuming so many.
No, but 33 to 35 requires the first point of judicial contact, that judicial officer to see that factor.
My lord, that's the point. In normal cases, yes. In all other cases, yes. The judicial officer, regardless of the parties before him, must see the document and must address his point to stamping. So many cases, my lord, in tax matters we've seen in the High Court, neither party says anything. The judge says it's unstamped. You first cough up the money. But my lord, is that general test to be applied to
With an 11.6.
That's the only question, my lord. Generally, yes. Yes, my lord. Of course, he has to look at it because he's a judicial officer, my lord.
So you are relying on that existence in 11.6.
Confined, my lord,
To
to
s-
examination. My lord, the word used is examination.
So
which is the-
according to you, if in the agreement there's an arbitration clause written, then it is in existence.
It is in
whether it's
existence
stamped
for
or
the
not.
limited purpose of it's subject to it being, my lord, patently void. There may be some extreme situation, maybe, my lord, unstamping may come to, but it's not patently void, my lord. Supposing it's absolutely illegal, then your lordships will not appoint. It is not that there is, that is that thin line which has been drawn in Vidyadrolya. The question is, are we expanding the circle? That's the only question, my lord.
So how does Justice Nariman approach it and hold?
Let
that?
us show the, my lord, let me now show the three judgments,
Yes.
before judgment.
Yes.
Where, according to me, my lord, there is a problem. Let us first see, my lord, Garwari.
I have my 7-minute length.
Only 3 or 4 judgments.
That's it.
That's
Anyway,
what,
they will
what
also
there
refer
is
to
to it. And then, my lord, actually, Vidyadrolya, I would beseech your lordships to look at a little carefully, because there are all sorts of things in Vidyadrolya which were perhaps, my lord, not required and are causing, because let me first place Garwari.
Yeah.
Let me first. My lord,
This is Nariman's judgment, which is that.
Just Garwari.
Garwar.
Garwari.
Let's see that, because that is what is called its lordship finally.
The judgment begins at page 8. Justice Nariman's judgment begins
Yes.
at page 8.
Let's straightway we'll go to the discussion of.
My lord, I just want to, if your lordships permit me, since
Yes.
it's a reference judgment,
Yes.
two, three paragraphs, my lord, because I believe it's been put very well. Please come to para 3. At the bottom, page 8, the question is whether 11.6a, which has been introduced by way of arbitration conciliation, has removed the basis of its judgment so that the stage at which the instrument was to be impounded